Okay, so again, welcome to everybody on the webinar today, the future of third-party compliance in Europe, how regulations and technology are impacting upon or driving third-party compliance programs. I'm Robert Bond, and I'm joined by Allan Matheson, whom I will introduce in a moment. We've already had one or two questions in, and just to answer those, yes, the webinar will be recorded and will be available for download in a few days' time from our website, and I'll remind you again about that at the end. And for those that want to send in questions, you can do so at any time by using the questions box. I'm going to take us through the legal and regulatory drivers for third-party monitoring, and then Allan is going to be looking at how to use technology to assist in this. We'll take questions at the end, but of course, if any of them are absolutely pertinent to what one of us is saying, then we'll take them as we go along, and I'll make that judgment call. So turning to the next slide, I think many of you know me. I'm a partner here at Bristows. I now specialize almost exclusively on data protection and data breaches and cyber risk, although I have in the past dealt with other compliance related laws such as anti-money laundering, FCPA type issues and so on. And that's partly the driver for why Allan and I thought this would be a good webinar to get out to our contacts and clients today. That's enough about me. Allan, if you can unmute, I'll let you introduce yourself.
Sure, thanks a lot for that. So my name is Allan Matheson. I have now close to 2 decades of experience in helping to formulate technologies around compliance business processes, including in my current role. I'm the CEO of Blue Umbrella. We're one of the largest third-party compliance technology and due diligence providers. We have 250 staff in offices around the world. These are full-time employees sitting in London, Sao Paulo, India, Hong Kong, and Vancouver in Canada, which is where I'm based. So thank you all for joining today. Look forward to speaking.
Thank you, Allan. So why is this a key issue for us? Well, and I'm looking at this from the EU, and this is not an exhaustive set of examples. And indeed, I know Allan is going to talk about the French Sapin II law, but we've got, or we've had anti-bribery, we've had anti-money laundering, we've got things like the UK Modern Slavery Act, we have competition and antitrust laws, we've got the Trade Secrets Directive coming along, which I will talk about a little bit later. We have the Network Information Security Directive, which is going to be coming in shortly into each member state that is not dissimilar to the US NIST standards. And then, of course, we've got the impending General Data Protection Regulation, which I can't imagine anybody hasn't heard about by now. And then we have got equally the draft ePrivacy regulation, to name but a few. And then sitting below those will be the localization laws across numerous member states and other parts of the world where there is a requirement by law, if not as a result of pure compliance and governance, for the business to better control their risks when those risks are handled by third parties, whether corporate third parties or whether individuals in those corporate third parties. I'm going to major for the first part of the presentation on GDPR, and apologies to those of you who've had more GDPR than you know what to do with, but I thought I would pull out of the General Data Protection Regulation some points that drive us towards the consideration of third-party monitoring and compliance. So next slide, please. If you weren't aware, please remember that the General Data Protection Regulation, which comes in on the 25th of May this year, so less than 100 days to go, applies to both controllers as well as processors. And when we look at what that means under EU law, the controller is the business that makes decisions in relation to personal data, and the processor is the third party that acts on the instructions of the controller when managing the use of that third party data. Those processors may be call centers, cloud providers, third-party vendors managing travel and expense claims, reporting systems, the sort of PeopleSoft, Salesforces, Concurs of this world, background check companies, literally anybody that touches your data as a controller when it's in their hands. That wasn't the case. Currently, processors in general are not bound to comply with the European laws, but from the 25th of May, the processors will need to do so. That's not all of the compliance falling on the shoulders of the processor. The buck will still stop with the controller when things go wrong. And then also you'll see on this slide that there is an extraterritorial nature to GDPR in that it applies to any business anywhere in the world if it is as a controller or processor offering goods or services to individuals in the EU, whether for money or not, or monitoring the behavior insofar as that monitoring takes place in the EU. It is catching out a lot of non-EU companies, particularly those that are processors, who are now being subjected to due diligence by controllers to say, do you contractually, practically, technically help us manage our compliance with GDPR? And if you don't, then we either need to get a contract that makes you, or maybe we just go and find somebody else that will. So there is a lot of pressure on third parties to up their game in terms of ensuring that they make their controller customers feel protected and loved. And GDPR specifically places three major obligations on processors. As I say, processors being the individuals or businesses that process data for controllers, to have adequate information security, such as technical and organizational security measures, to tell the client controller as soon as they are aware of an incident relating to personal data, to cooperate in the investigation that may be carried out by the DPA, the Data Protection Authority, or indeed claims made by individuals who feel aggrieved now that their data has been mismanaged. And there are extensive requirements in GDPR relating to how contractually you have to ensure that the third party is complying. So I've just put up on the next slide a bullet point extraction of the key factors in GDPR. Firstly, it's the controller, that's us as businesses, that has the obligation to ensure that the processor will comply, hence my comment about due diligence and the appropriateness or suitability of that processor processing that sensitivity of data. And that does mean that we're looking a lot more at cloud-based providers, at call centers, aftercare, call centers, hosting companies, etc. And there needs to be an appropriate contract between the controller and the processor, and that contract needs to stipulate that the company has adequate information security. And it's not just the contract that needs to say it. The business will need to think, how do we practically ensure that that level of security is there? And that may be a physical due diligence issue, but it may also be something where a technology solution is what you need to bolster the legal contract. The processor can't use third-party sub-processors without permission of the controller, and you can write that into the contract, but you've still got to have mechanisms that monitor that on a real-time basis. As I said, the processor has to cooperate with investigations by data protection authorities where they've received a complaint or where there's been a publicized breach or incident. The processor's got to report breaches within as soon as possible after becoming aware of it. But contractually, we're starting to see controllers saying, we want to know within 24 hours of you becoming aware of an incident that there is an incident, because we as the controller have got to report it under EU laws within 72 hours of becoming aware of it. So there's a time driver. Processors may need to appoint a mandatory data protection officer if, as a processor, they are systematically processing large volumes of data about individuals, particularly where the data is sensitive, so health information, criminal background checks, religious or philosophical beliefs, ethnic origin, and so on. Or where they are monitoring systematically on a large basis. A question I would want to ask of every processor is, have you appointed a data protection officer? Who is the data protection officer? Do we feel comfortable that they are competent for doing the job to help us as the controller meet our needs? Processors need to keep a record of processing under Article 30 of GDPR, which very much needs to be driven by a technical solution. It could be a paper record, but basically it's a real-time record of who the processor is, every contract the processor's had with a customer, how they're managing sub-processors, what the terms of those contracts say, whether they carry cyber insurance, and that sort of thing. And not keeping the record is a direct breach of GDPR, one of which can lead to those sorts of large fines which we've heard about and which I will come back to. Where processors are not inside the EU, or more correctly, the European Economic Area, that's the 28 member states of the EU plus Iceland, Norway, and Liechtenstein, they have to comply with the GDPR requirements on international data transfer solutions like Privacy Shield, if it's EU to US, or binding corporate rules as a more robust code of practice, or standard contractual clauses or model contracts, as we refer to them, which the EU have mandated. Processors need to be controlled in terms of how to manage when data subjects exercise their rights. And we anticipate, with the enhanced rights under GDPR, that we will see a spike post-May of individuals saying, this is my right, I am going to make your life hell by exercising my rights of erasure, of portability, the right of access, etc. And now processors will also be directly liable for non-compliance. So just by way of a call to action, here's the proactive things that I think need to be dealt with by controllers vis-a-vis processors in terms of suitable contracts, documented instructions, managing not just privacy but confidentiality, controlling those sub-processors, having strict rules as to how the processor will, or more likely should not, be responding to a a request from a data subject. Indeed, that is not the role of the processor. And I've had examples over the years of processors responding to a subject access request that was served on them when they should not have done so, with no protocol in place, no standard operating procedure, and then exacerbating the problem that the controller is left with. So we need to think, how do we nail that one down? How do we ensure that the data is appropriately managed at the end of the contract life? Is it going to be destroyed, or is it going to be handed back in a technical form that will enable its future use or portability to the controller's new choice of processor? And generally, we need the processor to prove compliance to GDPR to the satisfaction of the controller. Hence, it's not all about contract. There's an awful lot of requirement for technical assistance. Moving on to the next set of slides, I'm drilling down to a particular issue which Allan and I discussed, and that is it all about consent when monitoring is being carried out in the workplace, background checks are being carried out, third-party due diligence is being carried out? There has been an awful lot of media focus on it's all about consent, but it isn't all about consent. Indeed, I have quoted recital 47 from GDPR that flags up that there are several lawful, or as one of my clients calls it, awful grounds for processing, of which consent is one, contractual necessity is another, and also the need to comply with other laws like anti-money laundering, FCPA, and so on. But then there's also the legitimate interest of the controller, where consent is inappropriate. And indeed, in the workplace, the regulators and indeed GDPR makes it clear that consent really does not work in the workplace because of the imbalance between the employer's power and rights and those of the employee. So it's not a bad thing to make staff aware that monitoring will take place in terms of compliance with the law, but that's information, that's not permission, because you would be able to rely on legitimate interest if you follow the available guidance. I've put up there in the final italics something stated by our UK Information and Commissioner Elizabeth Denham, which is that the guidance from the Data Protection Network, which I chair, which includes a lot of multinational organizations that help put the guidance together, provides a very good template for businesses to follow where they want to show in anger that legitimate interest does not override the rights of individuals. So moving on to the next slide, literally in the DPN guidance, we've broken it down into trying to understand what are the lawful grounds for processing, and it's not hierarchical, and why you can use legitimate interests legitimately. GDPR is really helpful, and I have just, without getting into too much detail, flagged up here that the law says you can use legitimate interests for direct marketing if you've got a contractual or some relationship with the individual, or if it would be in their reasonable expectations. But if we look a little bit further down what the law says, legitimate interests may substantiate monitoring if it's necessary to prevent fraud, or if it's necessary in the course of a corporate restructuring, merger, acquisition, pre-IPO, due diligence, etc., or it's necessary for network information security. So it isn't all about consent. And I would urge businesses to try and adopt this concept of a legitimate interests assessment as something to embed into your processes in terms of trying to demonstrate in some auditable format why you deem your rights necessary, what are the purposes for using legitimate interest, and how it doesn't overreach the rights and freedoms of the individual. And that we do through a legitimate interests assessment form. It's where I think you have got a good risk management tool that is out there. Why else do you want to manage third parties in relation to personal data? Well, I put up there that damn breach or that damn breach. We have a 200-year-old case decision in the UK called Rylands and Fletcher. It was about a farmer whose dam breached because it wasn't built well, and the water flowed down the hillside and crushed the crops of the farmer at the bottom of the hill. When he sued, the judge said, if you are responsible for keeping something in which, if it gets out, causes damage, and you cannot show you took reasonable steps to keep it in, then you have strict liability as a subset of negligence. And I flag this up because I can foresee when we get more Equifax style breaches, or we have breaches that happen in the hands of your third party processor, there will be the next round of whiplash claims, of personal injury claims, no win, no fee. And indeed, I read an article a little while ago written by professors at UCLA in California, where they referred to the case and talked about cyber reservoirs, the water now being replaced by data. So think about that one. And in terms of cyber type issues, again, nothing necessarily to do with data or personal data per se, but when we start to look at things like the Network Information Security Directive and the general increase in cyber warfare, nation-state sponsored attacks, how do you manage those risks? And in the third bullet point, how do you manage third parties that are in the ecosystem that you are using in relation to not just personal data, but data and information? Due diligence, technical monitoring, and so on would be the sort of things that you need there. And I wanted to finish with one other piece of legislation, which is the Trade Secrets Directive, which not a lot of people have focused on. It's sort of crept in there under the radar, so to speak. It is driven by the fact that in Europe, we have a common understanding legally of what a patent is, of what registered designs are, of what trademarks are, of what copyright is, but business confidential information or trade secrets, there is no common definition across each of the member states. So a little while back, from an IP perspective, the Directive on Trade Secrets, as I call it, that's not the technical name, was drawn up, amongst other things, to provide a common definition of what is a trade secret. And I put up there what's in the directive and what is now being implemented in each member state at the same time as we have GDPR and everything else going on, which is for a trade secret to be protected, it has to be secret. And you need to take steps to show, if you went to court to get an injunction to prevent somebody using your business information that your employee has stolen or extracted on a Gmail account or a flash drive, etc., you have got to show, if you think it's a secret, that you took steps to keep it secret. And that's now driving us to say, well, what do our non-disclosure agreements say? What do our confidentiality agreements say with our staff? But what do they say with our third-party agents, contractors, data processors who may also be hoovering up confidential trade secrets? What do we say in the contracts about defining a trade secret? defining how this new newly defined intellectual property is being managed. And that drives us to also thinking about what do we do with the use of bring your own devices or bring your own disasters in the workplace, the use of apps, the use of other solutions where we may inadvertently or advertently allow what we regard as confidential to be put into the public domain, and we would then have great difficulty in getting it back. Training and monitoring needs to be implemented. And I will finish by just quickly saying there's been a case recently in the UK against a food retail outlet called Morrison's, where a disgruntled employee of Morrison's who was unhappy with his annual bonus or compensation hacked into the IT system and the HR database and put on the dark web 3,400 employees' information, financial records, passport details, social security numbers, etc. We're waiting for damages to be assessed, but the decision of the court was even though the employee was a criminal, had hacked into the system, the employer was vicariously liable for the criminal acts of the employee, and therefore they will have to compensate each of those 3,400 employees for the emotional distress, not the financial damage, the emotional distress. And you think with hindsight we should have had better security, with hindsight we should have done better training, and we can't do that just with paper. We need to have the assistance of technology in managing compliance, which neatly leads me in to Allan. Allan, over to you.
Great, thank you very much. You know, it's interesting. I think, you know, your remarks really help to show some of the complexity that is really out there and the degree of granularity that we have to get into, that we have to understand, that we have to bake into our processes when we're rolling out a third-party compliance program. And I see that at one end of the spectrum, that, you know, to try to understand all of the regulations, to try to make sense of them in your program, to get down to that level of granularity and take them into account in all of your third-party compliance processes, is at one end of the spectrum. And at the other end of the spectrum, we have technology. And technology is able to collate those processes, to be able to roll them out with consistency, to take into account that granularity and adjust for it, and ensure that a third-party compliance program is really well-maintained and well-designed and takes into account all of that granularity at the same time. So I'm going to talk a little bit about some of the technologies that are out there that we can use in the third-party compliance systems, processes. I'm not going to talk, obviously, about anything that's vendor-specific. I'm going to start by talking about the technologies themselves. And it's very difficult to, you know, read a newspaper or look at a website these days without seeing anything about artificial intelligence. We have AI, we've got automation, we have APIs and integrations. These are some of the technologies that I'm going to speak through. Next slide, please. So the first thing that I'm going to talk about, though, is this lovely young woman whose name is Lady Ada Lovelace. As you can see, she lived in the early to mid 1800s. She died when she was 36 years old. She was actually, incidentally, the daughter of Lord Byron and a partner of Charles Babbage, who, together with Lady Lovelace, who was one of the original, who was sort of commonly looked at as the first computer scientist. She and Charles Babbage had pontificated that they could make up an analytical engine, meaning basically a computer. And so they had designed this idea, and she went one step further. She actually made the first computer program. And she was also somewhat of a philosopher. She said, the analytical engine, in other words, the computer, has no pretensions whatever to originate anything. It can do whatever we know how to order it to perform. In other words, we can write algorithms that a computer will understand and execute to affect the goal that we are trying to reach. And this is very much the history of computer programming thus far, has always been about that, about create a program to complete a specific task and make sure that that task is completed successfully. But when you read the newspaper, when you look at what's going on in technological advances these days, everybody, of course, is talking about artificial intelligence. If I could have the next slide, please. Artificial intelligence, though, is not necessarily a thing. It's actually not a technology necessarily in and of itself. It's a combination of many different components of technology. And those different components, those algorithms, are there, and they combine in such a way to help create some semblance of intelligence. And the holy grail, of course, of artificial intelligence is what we call strong AI, or artificial general intelligence, meaning this ability for a set of algorithms to act and create sentience, basically to act as though they were a sentient being. So what I want to do is actually break down some of the different components of artificial intelligence and talk a little bit about what those different pieces are, so that we can then understand how we can start to apply those kinds of technologies in a third-party compliance workflow. So first thing we have is knowledge representation. That means basically tons and tons of data and making sense of that data. So if we have the computer read a sentence, I put my hand next to the fire, through knowledge representation, it would understand that my hand is at least getting warm, it may get burnt, because fire is hot. We have natural language processing. NLP is very much just understanding language, understanding how it works together, of course, all different languages. Machine learning is possibly the most important and most complex part of the artificial intelligence components. Deep learning and neural networks are subsets of machine learning, but essentially the ability for machines to teach themselves. And this is where a little bit sometimes of the ambiguity around the artificial intelligence comes in, because when machines teach themselves, we don't always know why it takes a certain action. We know that somehow it learned that. We don't always necessarily know why. And this has, big ramifications for things like autonomous vehicles. Of course, we've got perception, so computer vision or speech recognition. We've got robotics. I don't think robotics are going to come into too strongly in third-party compliance unless we're going to send robots around to collect recalcitrant questionnaire answering amongst our third parties. We've also got computational creativity, so creating actually algorithms that are creative. And one of the ones I'm going to talk quite a bit about is automated planning and scheduling. And that's basically automation and automation engines specifically around decision making. And there are some very complicated, complex algorithms going on one side of this spectrum around planning and scheduling and prioritizing tasks. And then on the more simple side, we have things that are very applicable to the third-party compliance technologies. And last but not least, we have artificial general intelligence. And this is what I mentioned before about sort of combinations of these and other to reach some type of, strong AI state. Next slide, please. But I think for anyone who's really used, for instance, Siri, we know that, yes, there's a degree of intelligence there, but I think if we tracked all of the cursing that goes on after we use Siri sometimes, we'd understand that the artificial intelligence involved in some intelligence is not that intelligent. And really what I'm getting at there is that most of the systems that are currently using these technologies are very purpose-built. So there's a famous Dutch computer programmer who said, he said, the question of whether a computer can think is no more interesting than the question of whether a submarine can swim. In other words, we can program these things, we can use these pieces of technology, but they're based on two things. One, on reaching one specific outcome for one specific to one specific goal. So if we're using these technologies, we're using them to reach some specific goal within our third-party compliance program. Secondly, most of them are based on rules-based expert systems. And what that means is essentially experts, human expertise forms the basis of those programs. And so it's not some type of sentient being. It's generally based on human knowledge. It is looking at how do we employ some of these technologies to reach a certain end. Can a submarine swim? It's a silly question. It's a submarine. Next slide. That was hitherto true, but I don't know whether you heard about it, but there's a program called Alphago. Alphago is a program that was programmed by DeepMind, which is a subsidiary of Google. And Alphago in March 2016 beat Lee Sedol, one of the masters of a game called Go. Now, why is this interesting? Why is this important? I appreciate we're talking about third-party compliance. Why are we talking about the game Go? It shows the power of where artificial intelligence is beginning to, is really the kind of power where it's starting to reach. So we all know also that the IBM supercomputer beat Garry Kasparov. I believe that was in 1997. So why is this important? Go is actually a much more complicated game. So they say that the number of possible games in chess is 10 to the power of 120. The number of possible games of Go is 10 to the 761st power. And just for reference, the number of atoms in the universe is 10 to the 80th. So if you talk about the amount of computing power that would be required to just figure out every single possible game and figure out what the best way to go about winning any given game, for Go, 10 to the 761st power is just too much. It's too big. And so instead, it implies that Go implies, it requires creativity, it requires intuition, it requires strategy, it requires reading your opponent, things that for a long time people thought computers would not be able to do. Well, in March 2016, AlphaGo beat Lee Sedol. And what it did that by doing it in a very unique way. And this is where the artificial intelligence is really starting to come on. They did use expert information. They sat down and they taught AlphaGo, they gave AlphaGo access to 30 million games of Go. And on top of that, they actually let AlphaGo play different instances of AlphaGo. And it learned from its behavior. And what happened was really intriguing. In game 2, and I've put the YouTube links here for you if you want to take a look. In game 2, a move was made by the computer, which was absolutely astounding. The commentators didn't know what to think of it. They thought it was a mistake at first. Lee Sedol himself got up from the table and walked out. He was gone for 15 minutes. He didn't know what to think of it. It was a move that was so extraordinary that no human would play, and yet it was the game-winning move. It was the move that basically helped AlphaGo win. And it goes to show that, you know, if a computer can teach itself to be not only better than humans, but not to not play into our bias, that it's extremely powerful. Subsequently, AlphaGo or DeepMind released a new version of AlphaGo called AlphaZero, and AlphaZero actually took out the human expertise part. It just taught the rules of the game and then let it play itself millions of times. And that version actually beat this version 100 games to nothing. So the takeaway is the kinds of technologies that are out there are extremely complicated, they're extremely complex, and yet when done right, when configured properly, they have amazing opportunity to assist. Now, let's turn back to third-party compliance. How can we start to affect some of these technologies and apply some of these technologies to the environment that we're in? Can I have the next slide, please? Incidentally, AlphaZero taught itself to be a grand chess master and basically unbeatable at chess in a period of 4 hours. Okay, So where are we at with our current processes? How can we apply some of this technology? Taking into account the current sort of environment of your third-party compliance program is really important. You know, how much information is out there? What format is it in? What tools are you using? And really, if you look at, you know, trying to pull data from Excels, from PDFs, from email and physical documents, then you look at what systems are utilized. You've got, of course, procurement systems. Maybe you have compliance systems. And then where is the data? You have some data that's relevant that sits within compliance. You also have HR, you have finance information, you have procurement information. And so when we start looking at the kinds of data that would be required to make sense of, really you have to look at also physically, organizationally, how set up are you in order to start applying some of these technologies? And I think most of us are in complex organizations. Most of us sit in organizations where to wrap all of that data together and then start applying some of these really advanced algorithms, we're probably a little bit farther away from that at the moment, but some technologies are helping to pull things together. And really the process of pulling it all together comes, I think, by biting off the easiest parts of the third-party compliance by looking at the workflows. So if I can have the next slide, please. Really, third-party compliance, a lot of it is not necessarily about complex decision-making. It's about process. And so here is a typical process. I've put down a few different steps. Of course, there are lots of different steps that we can apply. And in fact, no two companies even that if they're in similar jurisdictions, in similar industries, no two are going to, processes are going to look the same. So it might have some business justification, some kind of submission from the front line, approval, questionnaires, maybe third party signs off on code of conduct. You've got review of information, so risk rating or risk assessment based on some of that information. You've got, of course, due diligence and research processes which feed into that, contracting. Then you've got some of the training mechanisms, and then on an ongoing basis, you may have ongoing monitoring. You may have updating information. And then, of course, you've got recertifications and those kinds of things. And really, if we go to the next slide, part of the issue with those workflows, and that one just as an example, some of the really key challenges are process design. Process design is not easy, but one of the most difficult things is it has to be both cohesive and comprehensive and rolled out on a global basis. But at the same time, coming back to Robert's remarks, it has to take into account the granularity. It has to take into account, potentially different regulations, different legislation, different cultural issues, different languages. And so operationalizing a process can become very complicated. And this is somewhere where we can look at some key technologies to help us. We can look at automations, we can look at different workflow technologies, we can look at different ways of managing that such that we have a cohesive way of dealing with our third-party universe. One of the other major challenges that we see in such a sort of workflow-heavy environment is that we're all dealing with a lack of resources. And so, I mean, actually, my history, when we first started, we were providing, and we continue to, large amounts of due diligence to Wall Street banks, and it gave us kind of a warped view of that due diligence issue, because banks have such vast resources at their disposal that when you move into non-financial institutions, it's always, they're always much more resource strapped. And so if there's only, a couple people in the compliance department, and yet there are 10,000 or 50,000 or 500,000, relationships, third parties, then even if something only takes 20 or 30 seconds, that's a massive drain on resources. And that ties really into the last point as well, which is just the administrative burden of administering the program. There's not a lot of value often in moving one third party from one part of the workflow to the next part of the workflow. the results of those different parts of the workflow are important, and contextualizing those results is important, but moving it from one part is somewhere where I think technology can really assist. And so if you go to the next slide, there are two areas that I think really can assist tremendously. So the way that technologies are built now, given modern roots and modern foundations in terms of databases, in terms of UI, there's a lot of different opportunity to offer flexibility. And one of the issues that we see is that, as I said, no two companies have the same compliance program. People have different terminology, they have different, of course, relationships, they have different data relationships, they have different risk criteria, and the ability to modern technologies are built such that you're able to offer a massive degree of flexibility within that program so that you can calibrate technologies precisely around the workflow that you've chosen. So that any of these blue boxes you could take and put in different positions, you can have them run totally differently, you can have different workflows for different criteria, but the flexibility is really important. And a lot of the technologies that we're talking about in terms of automation, in terms of learning which different workflow third parties belong in, those can all be calibrated given modern technologies. The other element is really about automation. And as I mentioned, if you've got 10,000 third parties and you're going to, for instance, the third box there is looking at some of the database information. If you're going to be looking at the databases and you need to do, someone on your team needs to do that 10,000 times, well, even if it only takes 20 seconds, that's a massive drain on resources. And so the other thing that we should be looking at in terms of some of the technologies we're plugging in is automation technology. And especially where there's a very clear criteria set around a very clear outcome, all of those things can be automated. So go into the database, do the check. If there are no hits, in this example, send a questionnaire. If the questionnaire isn't answered, send a reminder. Do this. If we need a reminder on the 6th day, then copy the business person. All of those things take up a massive amount of time in the program, and yet they don't offer that much value. And if we go to the next slide, this is where we want to encourage that technology is not there to make the program run on autopilot. In fact, just the opposite. In fact, it's about freeing up resources and applying things like deep learning, applying things like automation to relieve the resources of their administrative burden and allow them to concentrate on those truly exceptional things. Here's an issue. This is a potential issue. AI might be smart enough to start wading into, how should we handle the issue, but we're miles away from that. What we want to do is to be able to say, here are some things that you should look at. The technology can bring things to your attention. And there are very effective parts of technology that are working very well to do that. And then that really frees up your team to do what they do best, which is, yes, this is a potential issue. Here's how we're going to remediate it. Here's how we're going to handle it. Or, okay, thanks a lot for that. This actually doesn't look like an issue, sort of as you were. And so the ability for technology to help point out and handle the exceptional issues is really very important. Okay, can I have the next slide, please? Another element of technology that we really that we want to focus on is the ability for technology to integrate. So as we know, compliance is very sort of multidisciplinary. Compliance deals with HR, compliance deals with legal, compliance deals with finance and procurement, and none of these things operate independently. They all interact. And so through the use of effective APIs, we also need whatever technologies you're going to be using to be interacting and integrating information. And these integrations generally run in one of two ways. Either the compliance system is used as sort of an absolute system of record, in which case we want information to be coming in from, you know, the CRM. We want information to be coming in from the business people. We want information to be directly coming in from research teams, where all of that research at a granular level can be very much fed into the system so that we can get those exceptions out from it. And so that's one model. Or that another common model is that through integrations, we have a third-party compliance software that runs basically as an engine. It runs into the engine of the compliance workflow. The workflows are managed and monitored and run through the software, but then there are other systems of record. And then it's very much about putting the results from the compliance system into other systems. And either way, we need to make sure that both within the system, we have very good integration of information, and externally we have information that's able to come into the system and go out of the system. And through modern API technology, that's really you know, a basic thing that we should be looking at. Next slide, please. Okay, I'm not going to talk very much about legislation. That's already been, you know, well covered by Robert. I think one of the things that I just wanted to touch on was very much about when we have an effective technology, if there are elements of regulation or legislation that we need to take into account in our program, that we're able to do that. And so that the technology can very effectively say, okay, in Korea, we're not supposed to take the ID card number of any Korean national. We're not going to take that. Or we have certain data retention policies to fit GDPR or whatever other legislation we're talking about. So let's calibrate the technology to look at data retention. And so the technology can be very powerful in helping to address the granularity of that regulation or legislation. Next slide, please. Language is also extremely important. We want to make sure that the technologies are using NLP, that they're using translation software in order to be able to assist in dealing with third parties. So for instance, all the interactions around questionnaires and those kinds of things should be in local language. And as results come back, we can also look at, for instance, translating the responses. But I would also guide you that there are limits to technology. Technology is not perfect, and it's definitely got some areas where it has far to go. So in the research capacity, for instance, also using translation software rather than using humans that actually speak the language, there's still a massive difference there. And so technology can be powerful, but there's still areas where we should look at the efficacy of that technology and decide, is that something that is going to be an effective use of technology? Next slide, please. So just to sort of summarize some of the key points that I discussed. As you're building your program, you should be looking at not only the kinds of technology that are at your fingertips now, but the introduction of new technology. What is on the roadmap? What are you looking at in terms of artificial intelligence? Are you looking at, you know, deep learning and some of the algorithms there? And how can we be better capturing these exceptions? Of course, server location and data security measures, everything from, you know, looking at ISO certification, ISO 27001, penetration testing, third-party IT tests, security assessments, DPOs, all of those things should be taken into consideration. Automation is really key, and understanding whether automation comes from a set of automations or if the automations are very calibratable. That can be an extremely powerful part of modern third-party technology. A lot of this builds into risk flagging. So the ability for the system to intelligently flag risk based on the criteria that makes sense for your organization, and as your, you know, legal counsel may have drafted it or whatever the case may be, but in a flexible way to be able to conform that risk flagging to your organization. Integration and language I've spoken about quite a bit, and then finally we have flexibility. So to conclude, I actually led you a little bit astray earlier. Not astray, but I mentioned that, if you go to the next slide, please, I mentioned that actually Alphago had won 4 out of 5 games. And so I'm going to read something to you. I apologize, I know it's not very charming, but I thought this was really well put. So coming back to Alphago's match against Lee Sedol, one of the champions of Go. In game 2, the Google machine made a move that no human ever would, and it was beautiful. As the world looked on, the move so perfectly demonstrated the enormously powerful and rather mysterious talents of modern artificial intelligence. But in game 4, the human made a move that no machine would ever expect, and it was beautiful too. Indeed, it was just as beautiful as the move from the Google machine, no less and no more. It showed that although machines are now capable of moments of genius, humans have hardly lost the ability to generate their own transcendent moments. And it seems that in the years to come, as we humans work with these machines, our genius will only grow in tandem with our creations. I thought it was just a really nice way of putting it, such that Lee Sedol was inspired by the machine. It made him a better player. And I think that's precisely what technology is capable of doing in our own space. And we know that when we're more effective with our third-party compliance programs, we have more resources to dedicate to more meaningful activity. And in essence, that makes our third-party network stronger, more ethical, and we are helping as compliance professionals to make the surroundings around us more ethical and a better place. All right, thank you very much. That's those are the only comments that I'd prepared.
Thank you, Allan. And we're coming towards the end of the hour, but I've got two questions that came in, which I think are more directed to me, but by all means, Allan, jump in. The first one is, do we need a separate GDPR agreement with third-party processors, or can we rely on prior signatures? The answer to that is you need to review the current contract you've got. If it doesn't contain the sort of language and representations that I mentioned earlier, then it needs updating. Now, it may not need completely renegotiating. Indeed, since you may well have in the business hundreds of third-party vendor contracts, typically we're dealing with those over here in Europe by sending an addendum to the third-party company to say, this is what the law requires, it's non-negotiable. We will either ask you to sign this agreement, or indeed, if we continue treating or trading together, we will deem it incorporated by reference, certainly from a US-UK common law point of view. Not every contract are you likely to get 100% right, but if the proverbial hit the fan, the regulator would be more focused on the fact you've done nothing than on the fact that you were attempting to move in the right direction in terms of managing your third parties. The other question I'd got, which is a really interesting one, I talked about criminal records. Somebody has quite rightly raised a question, which is, can an allegation of criminal behavior or criminal records themselves even be permitted to be processed? Well, I think if you look at GDPR, and criminal records are specifically defined as something which needs consent, there is also a challenge in that other laws require you to carry out background checks in order to comply with anti-bribery law or to comply with anti-money laundering. And it may well be in the course of hiring the next chief financial officer that you would be failing if you did not carry out checks on an individual's ethical performance or otherwise. And that's where maybe carrying out a legitimate interests assessment may lead you to say, we think that this is necessary for corporate governance, or it's driven by some other law and it overrides the right of the individual. Question is, when you receive those background checks, how long are you going to keep them? Because again, you can't keep personal data for longer than is necessary. It's not a perfect answer I have given you, but you can see that it isn't all about one law. It's about the balance between several laws or regulations or even your own ethical standards and codes of conduct. Another comment's come in about the need, whether there is a international data transfer to make sure that there is a written contract with the processor or third party, and that comment is absolutely correct. I'm just looking to see. One last question before we finish. Is it better to use the model clauses to manage third-party processors or to use other solutions like Privacy Shield, etc.? Well, that will depend upon whether it's pure EU to US or indeed the data may flow beyond that. And just throwing in the old Brexit wobbly, we are going to have some challenges in the UK when we are not in the EU, because then we'll be a third country like everybody else, and that's something that we're also trying to grapple with over here. This is all a moving target. The next webinar that we're going to be doing will be a compare and contrast between GDPR and the EU ePrivacy regulations and their equivalents in Russia and in South Africa. The details are on our website. On your behalf, I'd like to thank Allan very much for joining me. As I say, the recording will be available within the next 5 days from the events section, the cookie jar section of the Bristows website. If you have any one-to-one questions you've got for either of us, by all means email Allan or email me. And again, from Allan and me to all of you, thank you for your attendance, and we look forward to being with you on another occasion. Thank you. Bye-bye.
Great. Thank you, everyone.